What's up everyone, it's the Law School Lumberjack. I hope you're having a wonderful day. Today, we're going to be doing another installment of our Contracts Law 101 series, and today we will be focusing on the doctrine of frustration. Now, frustration can be a very fact-specific and fact-dependent analysis, so the purpose of this video is not to go into deep detail on the doctrine of frustration, but rather just to focus on the broad overview of the doctrine of frustration, what it is, some tests that are considered for frustration, and what the legal effect of frustration is on a contract. So without further ado, let's get into it. So the doctrine of frustration occurs when, after creation of the contract, an unforeseen event or circumstance makes it so the obligation set out in the contract cannot be fulfilled. So the typical example that a lot of law school professors will give, just because it's very tangible, is, let's say, for example, you have a contract for a sale of the house. One day, the ground just randomly opens up and the house disappears into the middle of the earth. Well, that is a situation, presuming that no parties could expect that, where the doctrine of frustration may be invoked. So as set out in several cases, one of which being Claude, Neon, General Advertising, and Sing, but there are other cases that set this out. There are two general types of fact scenarios where frustration could apply. The first one is where the contract could be carried out, but the circumstances surrounding that contract have changed. What you see in these type of cases is they often deal with permits, where the parties are expecting a permit to be granted and the permit is not granted, so that changes the nature of the contract or changes the circumstances such that the contract wasn't as contemplated. The second is where there's an act of war, act of God, that fundamentally changes the nature of the contract. So that's the situation, for example, where the ground opens up and the house falls through. Now, the general two-part test for frustration, again, is set out in numerous cases, one of which is Capital Quality Homes and Colwyn Construction, which is a case that comes out of the Ontario Court of Appeal. The first part of the test is whether or not the frustrating event could have been foreseen. And the second part of the test is whether or not that frustrating event radically altered the fundamental nature of the contract. So I'll go through each in turn. In respect of the first part of the test, which looks at whether the frustrating event could have been reasonably foreseen, if the parties to the contract, especially the person promising to do the action which is frustrated, could have reasonably expected the frustrating event to occur, then it is very unlikely that the court is going to step in and hold that the contract is unenforceable. So let me give you a bit of an example. Now I'll use a bit of a Wizard of Oz example on this one. So let's say Dorothy has had her house get swept away from Kansas in a tornado, and somehow the house lands back in Kansas. So Dorothy, knowing that there's a risk that this house could get taken away by a tornado, still contracts to sell her house to the Scarecrow. Well, if the house again gets taken away by a tornado, because Dorothy knew or ought to have known that the house could have been taken away by the tornado, it was her responsibility to put in certain terms in the contract that contemplated what would happen if a tornado took her house away, so it would not be considered a frustrating event by the courts generally. Now, moving on to part two of the test, assuming that the issue wasn't reasonably foreseeable, we have to consider if the frustrating event has now radically changed the terms of the contract. So using my previous example with the house falling into the middle of the earth, assuming it was not reasonably foreseeable, I think most courts would agree that a situation like that fundamentally changes what is being purchased by the parties. However, let's give a situation instead where it's not as clear, where maybe a permit isn't granted or the bylaws with respect to zoning have changed for a property. In that circumstance, the court's going to have to take a very close look at whether or not the lack of the permit or the zoning change has fundamentally changed the contract or changed it in a way that doesn't quite meet the threshold of radically changing the contract. Now, assuming that the court finds that the contract is frustrated, you may be wondering, what's the effect? Well, the effect is from the point of the frustrating event onwards, the contract, so all primary and secondary obligations set out in the contract, are held to be unenforceable. So anything that may have happened pre-frustration or any terms of the contract that were met and were dealt with pre-frustration are still valid and are enforceable, and if money has changed hands with respect to those obligations, that still stands. But anything after the frustrating event is unenforceable, and we can think of the contract as essentially not void ab initio, but void from the point that that frustrating event occurred onwards. I hope this video was helpful. If it was, I'd really appreciate it if you could like and subscribe. Thank you very much. Take care. See you next time.